Madam Chair, members, thank you very much. I appreciate the opportunity to present Senate Bill 329. Colleagues, this bill makes it clear that landlords cannot reject a tenant solely based on the fact that their rent is partially paid for by government. Across our state, Californians receiving housing assistance are struggling to use it effectively due to blanket policies of landlords who refuse to accept it. At the same time, local governments are increasingly turning to housing assistance as a way of shielding tenants from high housing costs and preventing homelessness. As reported in a Los Angeles Times editorial on the 19th of this month, Senate Bill 329 would not require that landlords rent to subsidize tenants. Landlords simply would have to treat tenants who receive rental assistance the same way they treat other prospective tenants. Property owners would still be able to screen tenants for rental or credit history, check references, and set other common standards. Cities and counties throughout California and other states throughout our nation have implemented what are called source of income protections for assisted families with great success. Cities in our state, including San Diego, San Francisco, and San Jose, have included them. The City Council of Los Angeles have very recently, as of last week, drafted an ordinance, and the County of Los Angeles is looking into it as well. Again, landlords would still have the ability to screen voucher holding applicants using the same criteria they use for any other potential tenant. This bill would bar them from refusing someone's application just because they get help to pay the rent. The U.S. Department of Housing and Urban Development published a report that looked at the accessibility of housing for families with Section 8 vouchers. That study found that for every 39 rental advertisements for apartments that a family with housing assistance could afford, there was only one that did not explicitly prohibit voucher holders from applying. Where source of income protections were not in place, denial rates for assisted families were as high as 75% or more. In jurisdictions with source of income protections, this denial rate was almost cut in half. This situation is unacceptable. If we found ourselves, for example, facing data that 75% of grocery stores refused to accept CalFresh and people couldn't use it to buy food, we would cry foul. We should not accept a situation for the housing assistance we give our struggling residents either, especially when there's a proven policy available to correct it. The housing crisis has hit hard for low-income renters. Rising rents, lack of available affordable housing, and stagnant incomes makes this population the most susceptible to falling into homelessness. You, colleagues, and the committee have received a number of letters of opposition and some concerns I'm sure we'll hear today. And so I wanted to address thematically some of the major concerns raised and challenge their position. Let me clarify that this bill will not increase the number of vouchers in the market, nor require that all landlords accept every voucher holding applicant. The bill requires landlords to allow assistant residents to apply while also allowing them to to apply their rental criteria to accept or deny a family with assistance in the same way they would any other family. Because the bill does not increase the number of vouchers, we don't think it will increase administrative burdens for the housing authorities across the state. If anything, housing authorities will benefit from the fact that a family will be more likely to successfully use their voucher rather than returning it when it expires and the housing authority being forced to reprocess and reissue the voucher. We're pleased to have the California Association of Housing Authorities as a co-sponsor of this measure. Further, the bill does not dictate what landlords may charge for rent. If an assisted family is able to afford the rent being charged, the bill allows them to apply, but does not force landlords to rent at any specific level or to comply with Section 8 payment standards. When someone with Section 8 voucher applies for an apartment because the apartment is inspected to make sure it meets basic requirements, we understand that there's a concern that that might cause an untenable delay for the landlord. The Housing Authority in Los Angeles is working to reduce the time for an inspection, for example, from what they report to be currently 1 week. The inspection should not be viewed as a burden, since it is performed to make landlords comply with their existing legal obligations for providing healthy housing for all their tenants. Lastly, there was a concern expressed about insurance premiums and if they would unduly increase. Insurance companies are currently barred from asking for information about whether housing assistance is accepted by a property owner. There was a bill previously, a Manshine bill, that covered this issue, but again, let me be clear. Under current law, insurance companies are barred from even asking the question about whether housing assistance is accepted by the property owner. Colleagues, the original purpose of housing vouchers was to help people attain affordable housing and enable families and individuals to move away from areas with concentrations of high poverty to areas with greater opportunities. Research demonstrates why this is a valuable way to have diverse communities for a variety of reasons in terms of access to green space, high-quality education, et cetera. This bill will enable families with housing assistance to successfully apply for and obtain housing they can afford in neighborhoods of opportunity without being literally turned away at every door and forced to return their assistance unused. Today, I'm proud to have with me Madam Chair Latoya McNeil, who's an affected resident who can tell us her own story, as well as Deborah Thorpe with the National Housing Law Project.